This is David Tulis. We argue here on the David Tulis program at Nooga Radio 92.7 and at 95.3 HD4. That's digital radio. We argue for local economy and the free market. And one of the things that we look at are free enterprise. And if you're going to defend free enterprise and the family and marriage and whole wheat bread, you've got to understand what the limits are on the good people in Washington and in Nashville. And even, get this, we have good people in the mayor's office, and we have good people in the city council. There are good people there too, and we have to watch what they're doing and what beneficence they plan for us this year and next year. Because often what they're doing is in being liberal, they're being liberal to themselves and being conservative to you. In other words, you get less and they get more. But there is one exception that we want to mention, and that is the liberalization of the ordinance in Chattanooga that will allow smaller farms to exist, not 20 acres being the minimum, but 5 and even smaller upon petition. That is a good move out of the city council. We're talking right now with Basil Marceaux, who is a man who's been at the wrong end of the police muzzle many times. He's been arrested. How many times, Basil? 50 or 60 times?
Well, I'd say 50. 51.
Okay, 51 times.
But it was not. Sometimes I did that on purpose. You got to fight in the court of law.
Right. If you're gonna make legal arguments, you have to have standing, and there's no better way to get standing than to simply exercise a liberty and have some officer say you can't do that. Right.
Yes.
Okay. So
you're under arrest.
You're under arrest, and you have
against
standing.
The law.
Yeah. So I think Basil, you've been the object of God's grace to make a good thing from an evil thing, because in the end you are distressed about the evils of being arrested. And then as you're arguing here, and as we've discussed in some detail at Nooganomics.com, the reasons behind this long work that you've had, suggesting that you may be the second smartest man in Chattanooga if I'm the first. Now, that with the bow tie, of course, I'm the smartest man with a bow tie. And since you're wearing an open collar sports shirt and a sports jacket, you could be the smartest person in your category, Basil. Maybe.
Well, I was said to be that.
Okay, Basil Marceaux is
more than once.
You're 65 years old.
65.
65 years old. Had a recent birthday, and a long time pro se litigant. He's argued his beliefs and his convictions about the statutes and constitutional government many times in court. His briefs are long and windy and sometimes confusing. Court clerks who have to deal with him roll their eyes when they get a fat wad of papers from the Basil Marceaux printer, because here comes Basil Marceaux again, and we have to disentangle what he's trying to say. So even though, Basil, there are things about your work that are mystifying and confusing, and some to me seem a little loopy, you are making important points, and that's what we want to talk about here. Not the, you might say, what I would call the kind of fruity claims that you make about. Just bear with me.
That's right.
You'll just take the abuse. Some unusual claims that Basil Marceaux makes, leaving those aside, and for his own personal presentation to you about them. The limits on governmental action is always of interest to me. And when someone makes an argument like that, that's not just poetical or editorial, but legal, I take notice. And that's why I have been trying to understand your arguments for some time, and have read the same court cases you have, some of them, and am trying to validate or invalidate your main argument. And tell my listener what your main argument is about the limits upon the municipal corporation known as City of Chattanooga, Hamilton County. What are the limits on this organization that are not being honored now in practice?
Okay, so let me start this. I have 15 mandated orders from the Tennessee Criminal Court of Appeals. Each one of them was signed by 3 judges. That's 45 different judges out of the 15 judges that we have. And they all ruled cities are civil and sheriff can't come in.
What does that mean? Sheriffs can't come in. What
That's
does
state
that mean?
law.
What does that mean?
That means the sheriff can't come.
The state law, cities can't enforce state law.
That's right. And the sheriff can't come in.
And the sheriff, who is the lawful enforcer of state law, can't come into the city corporation to enforce state law.
And that's in Davis out of the Tennessee.
Does that mean that city police departments have a limitation on their actions?
There is no police department.
Well, there is actually, Basil. There is a police department. It serves Mayor Andy Burke. It's part of the executive branch.
Well,
so what now?
See, it's not Andy Burke's fault. It's grandfathered into life. If someone made a mistake way back in 165, 200 years ago when they did all this, no one listened to the Supreme Court back then. The Bar Association was a new baby then. All that money was coming in left and right from the Bar Association. So it's not all local people's fault. They just following what their grandfathers have done. The chair that everyone sits in is the faulty thing. We need to cut the chair and put a new chair there, usually what the higher court says, because they're under the higher court ruling, and all the decisions that the Tennessee Criminal Court appeals made, they're nothing but a process server, and they're not even supposed to have a gun.
They, being the city police department, say East Ridge, Red Bank, Saudi Daisy, Chattanooga.
You just say the city.
The city. Okay, that would be every city
in Tennessee.
Okay, so every city in Tennessee, including yours, my listener, if you're from elsewhere, has a police department, and its authority is limited to process serving. All right, well, what is process serving? Just explain that right quick.
We use them as if you're suing someone to deliver papers. They're a paper deliverer, so to speak, and they don't use guns. They have
glorified mailmen.
Yeah, they're allowed to have mace for the dog.
All right. If police departments have that authority only, what else would they be doing?
They shot the terrorist.
They shot the terrorist. Okay. Well, that's right. A courageous Chattanooga police department officer took a bullet, and others shot the man.
Yeah, but they're not supposed to have a gun.
All right, why not?
Cities are civil.
Okay? Explain that.
Well, higher court cities are civil and can't do state crimes, and the sheriff can't come in. I don't like the idea of the cities being an anarchy, but if the Constitution says we're supposed to be one, well then.
All right, when you say cities are an anarchy, what you're saying is because they are their own corporations, they deprive themselves of the protection of the sheriff. That would be the sheriff of the county, in this case, surrounding Chattanooga, Jim Hammond. He can't come into the city to enforce statute. Why not? Why can't he come in? Where's the limit? Where's the legal limit for him? Why can't he do that?
Because of Title 6 of Article 14 of the Constitution.
Which says what?
The cities are civil and $50 law.
Okay, that's the $50 fine rule, an unusual rule exclusive to Tennessee among all the states.
As long as the cities are civil, well, there is no state law. Only ordinances that the commission makes. And
okay, this is David Tulis. We're talking with Basil Marceaux. Caller, what's your question?
So let me get this right, Basil. I'm going to tell you that no one can waive their constitutional rights. You don't have the authority to do it because God gave it to you. But on top of that, if somebody becomes a civil servant, they don't have a right to keep and bear arms. That right goes away.
No.
How does that happen?
No, you're talking the difference between individual people and people that work for the government.
The Constitution doesn't specify it. So now you're going to
when you work for the government,
you're going to be like the state and try to put words where they don't exist.
No. When you work for the government, you can't use your civil gun.
Really? Does it say that in the Second Amendment? It says the right of the people to keep and bear arms shall not be infringed.
When you got a job,
are they people or aren't they?
When you get a job, no. When you become a government official, you're not a person. You're a government official. At 5 o'clock, you're a person again.
You're not a people? Oh,
at
come
5
on,
o'clock.
That's baloney. Everyone has a right to bear arms. Everyone.
Mike, I think he's right. What you're saying is that the individual who becomes an employee of the city government maintains his personal rights in the hours of employment. And just you were saying earlier that that's not the case with Kaepernick and these sports players. Their employer controls.
Because he's coming after me with a gun of the city. He's not coming after me with a gun of his personal thing. If he comes my personal, I have a right to defend myself. And which means I can, if I'm better than him, I could smack him around, take his gun, and use it on him.
Oh man!
Because there's difference between government and citizens.
All right, let's get Mike. Listen, thanks for your call. We just got a call from Mike who was saying that officers have their Second Amendment rights and can have any gun they want? And the answer to that is no, because when you're employed, you are bound by the limits of the authority of your employer. So if you're a city police officer, you're bound by the limits of that office in your your employer, which is the city. Mm-hmm. And you're saying, Basil Marceaux, as employers can't have police officers with weapons, and cannot personal weapons, and even their own city weapons, because there's no authority for punishment by the city government through the executive branch agency, which is the police department. Okay, and why not? Why not?
Because the Supreme Court said so.
Is it a statutory reason or an opinion? Because high court rulings, after all, are just opinions, Basil Marceaux.
They use the Constitution, Title 6, Section 14. And they, like right here, it says, if we follow these, I took inserts out of Tennessee, Davis and Myers, Chattanooga and Myers, and I got 10 of them here. Each one of these statements say there is no punishment whatsoever inside of a city limits. Now, and the sheriff can't come in. Now, the sheriff can't come in. That means there's no state law, ordinances, and if a cop did use his personal gun to shoot me, he'd be fired.
When you say the sheriff can't come in, what you're saying is that the statute can't be enforced in the city limits, because that part of the county has been carved out of the county into a new corporation, which is the city, and it has only civil authority, like a private company, like a mall company, or a retailer, right? Now, no, really different than that.
Yeah. Then now the city hires a lawyer. The lawyer writes a charter, and in the charter it gives their judges the right to punish and the right to give penalty, overruling the Constitution and the Supreme Court, the Tennessee Criminal Court of Appeals, and the Tennessee Civil Appeals. So basically, everyone who comes out of those courts asks the question, can criminal court hear my case, does not have an appeal. Just like me. I got 20 cases here that I cannot get a correct appeal.
Well, the reason these rulings, Basil Marceaux, let my listener know something here. The reason that I take Basil Marceaux seriously is because he has these contradictory one-page rulings from the courts of appeal in the criminal and civil jurisdiction. In one case, one court will say, no, the appeal has to be heard in the other. And that other court says, no, the appeal has to be heard in the other case. So which is it? And these are cases that come out of city corporations. And because Basil's raising the right questions, he's getting these extremely self-contradictory rulings that imply that something's not right. Something is wrong in the way the state's government is operating through the judiciary branch.
But the worst thing I came up with, Dave, is the worst thing of the whole thing is that the Supreme Court appoints the Attorney General. The Attorney General hires 96 Attorney Generals in the counties to hire. And then they hire 150 people they need. They all come out here, violate our Constitution, allowing the city to give them fake, false arrest tickets to fight in judges. When they overrule our rights, we go back to higher court, ask them for if you have the right or not. They say no, but they have no policing power to stop them. So there is no police to stop them from doing what they're doing, because everybody's immune under the sovereignty of Tennessee. So it's one big circle thing. They say no. We can't do it. We're appeal court. No, we're appeal court. We can't tell them anything. And just no matter which court you go in, they can't.
You're getting the runaround. It sounds like you're making a circular movement with your hand here.
Not me. The whole society is getting the runaround.
That's right. But you are the representative of the society in these cases, Basil Marceaux. That's why I, your host here at Nooganomics, at the David Tulis Show, and on Nooganomics, I've given your claims very, very close attention, because clearly something is not right in the status quo. Amen. And you're saying, Basil Marceaux, that this system, which is malfunctioning, there's kind of an earthquake-prone fissure between systems, and there's movement. You're making some movement, and there's an earthquake. I suggest there's kind of an earthquake ahead when you're shaking of the ground, you're stamping on the ground with your feet like that, causes an earthquake. And we just have to see what the shape of that earthquake is. Go ahead.
Let me read this. This is a an extraction from Davis at 20.14, line 1429, 1432. However, this holding is no way involved the challenge issued by the District Attorney General Conference that the city ordinance is a violation of the state law. We reserve any discrimination on that issue for a later case. That's been 25 years ago, and no one, not one lawyer ever brought it up
that's
since.
16 years ago, and you didn't quote the best part of that part of the ruling at the last section, and that is that there is apparent. The court says that the way things are run now in Chattanooga, which typifies the cities across the state, are unconstitutional, likely to be unconstitutional, and it also says that these are disturbing. These are a disturbing operation. The court says, but the DA has to sue. The DA has to sue the state effectively to get his authority back. Is that
no?
Is that
he
right?
has no authority to come in. Never. He has to change the Constitution. But and then line 1434, we conclude Davis established a felony case demonstrating some policy and practice of the city infringes upon the District Attorney General's constitutional statutory authority in direct violation of our decision in Ramsey versus Town of Oliver in '99, and every city in Tennessee is doing the same thing.
Well, this opinion, I've read Chattanooga versus Davis 2 or 3 times now, and I've marked up my copy very carefully. But the court says we decline to take corrective action at this time on this. It is an abuse, and the abuse is that cities are effectively stealing the state's authority, and it's up to the district attorney to correct that. Only he has standing, and Davis didn't have standing. He was a citizen, didn't have standing, and the court would not address the issues that Jerry Summers. Jerry Summers. He won the case. We had him on earlier this week, and this is Jerry Summers' case. And the court says the court will not pass upon the constitutionality of a statute. The part I want to read is where it talks about it seems to be a continuing abuse, and that the state needs to vindicate its authority from the cities, effectively taking authority back that the cities are now exercising, and that the Attorney General has to do it. But it won't happen, Basil Marceaux, and here's why. The Attorney General, the District Attorney General, and the police department are allies. They both are involved in prosecuting and persecuting and pointing the finger and accusing the listener. They are the accusers. They work in league, in combination, as accusers of the listener and his family and his friends and his business associates. That's their job, to accuse.
Yeah, so he don't have to go to the Supreme Court to listen. The Supreme Court already talked. So did the Tennessee Civil Court of Appeals and the Criminal Court of Appeals. They all the higher courts above already ruled. He's in massive jurisdiction violation. Only thing he has to do is stop taking the tickets.
You know, what you're saying is that Neil Pinkston, the District Attorney General, needs to simply to uphold what the high court is suggesting in this case. Is only suggesting it because it's not ruling directly on these issues. What Neil Pinkston has to do is simply say, I'm not going to take any prosecutions of any criminal matter out of Chattanooga from the CPD. Is that what you're saying?
Well, when they talk about the Tennessee Attorney General Conference said that, I mean, so I think it's 15 conference people on there. They all said it, that there was violation. And just for that, he should just come out and say, we're no longer going to be taking anything from any city of Hamilton County. And then when he does that, every county in Tennessee will follow through. But as long as the Bar Association has to make their $135 an hour, everyone has to make money.
This is called the judicial-industrial complex.
Now, all the money they take from us citizens, they take equal amount from our public funds. We have to house these people that they were put in jail. Now, until everyone listens to the higher court, we can't take tax money to do wrong. We can't take citizens' money either. This is called slavery.
This ruling says that the appellant, that is to say Davis, lacks any legal standing to challenge what it calls the usurpation of the DA's, the District Attorney General's constitutional or statutory authority. And that's because
to have standing, you have to go to jail.
Yeah, and that's why you've been willing to go to jail in these cases. Is that?
Yeah, that's why I went to jail for these cases.
Because you're saying that there is not authority, and this ruling says that it is apparently unconstitutional, but it will not declare it outright. And so it seems like it's a hint. The judges in these two cases, Basil Marceaux, are giving a hint to the district attorney generals.
At the same time, Sessions Court has never been granted authority to impose a panel of jury. So he has to stop taking the cases
he
there
being
too.
The DA.
The DA can't take cases there either because they're civil and they can't do punishment either. According to this line here, it says no authority to or impose punishment not allowed under any circumstances under Article 6, Section 14. It says it right there.
$50 fine rule.
Yeah, it's all in there. You have, no jury, no punishment. So every case that comes in there, when he says, you have a right to a jury trial, you have a right to all this stuff, well, he's talking about circuit court. But now he's talking about grand jury. He pays the grand jury to do it. And no one, it's a one-sided jury. No one tells them about these laws on the side. Like you have 10 days to appeal to circuit court from criminal court. That's easy to remember. You're up there for murder, you go death row. The first 10 days, the Congress of the state has authority for the first 10 days. After the 10 days, the Bar Association law has jurisdiction. You have 60 days to appeal to Tennessee Criminal Court Appeals or civil appeal. But they don't say it. They don't tell people they can appeal to circuit court the first 10 days. That would make the whole city civil. I mean, the whole county civil. But some statutes they listen to, some they don't. But as long as they can make money, they listen.
Let's Basil Marceaux, let's see if we can summarize what you're saying. You're saying that courts, that district attorneys, that police departments are involved in a kind of a racket. The racket is that cities have authority to prosecute state crime, any state crime. They can use these corporation courts, which are called inferior courts, and they do that as a kind of
without a jury.
And of course the whole plea bargaining system is a kind of plea bargain mill. Hardly any cases go to trial.
Yeah, you have to, Deb.
Only about 3 or 4% of cases actually go to trial. And there's a plea bargain mill. The state is complicit with this. This mill of people, mostly poor and common people, are the ones ground down by this form of legal social engineering.
Yes.
In Hamilton County. And you're saying everywhere else.
And also,
is that fair?
Yeah, they took the law books away from the citizens. They can't even look up the law. It's hard to find. Like I'm still trying to find the ruling of the Tennessee Civil Court of Appeals about Davis.
On Davis. Well, I'm going to probably have to do an open records request, Basil Marceaux, on that. You've piqued my interest. What does it say?
Hey, it said what the Supreme Court said. Everything they said was okay, except for this. But they never said what they said. I mean, if you can't find it, nobody knows what they said.
Well, this is a growing mystery, Basil Marceaux. This is David Tulis, and we do thank you for joining us. Basil Marceaux, thanks for chatting with us.
I want everyone who has to file using a 27-4-101, appeal your case to circuit court within the first 10 days. And make sure that your transcript is there 10 days before you go to court.
This is David Tulis. We are glad you're giving us a few minutes of your time. These are complex issues, but I hope in that discussion you can see a little bit of what my concerns are and hear what Basil Marceaux has spent years arguing. And to little effect, it seems, and little public notice until I started reading what he had to say and pursuing his line of thinking, because it's a legal argument. It's not just opinion here. There's some legal argument and legal analysis. We're tracing with proof. We're tracing this work at Nooganomics.com. Nooganomics.com, our chief sponsor here. David Tulis, love your neighbor.
The Tennessee Valley's news talk leader, Nooga Radio, digital FM 95.3 HD4 and 90.